information you can use in your next real estate transaction. If you have a real estate question, you can call us anytime. That number is 281-882-8088. And anything we talk about here on the radio, you can also find more information on our website at HoustonRealEstateRadio.com. You can go there anytime and get links to our guest and see the videos and get more information about what we talk about. You can also tweet us any real estate questions you have using hashtag HRER, and also on Facebook. If you connect with us on Facebook and have a question, we'll answer it on the show as well. My guest today is Ian Faria. He's here in the RREA.com studio with me, and Ian is the director of the construction and real estate sections of the law firm Coates Rose. So he has a lot of interesting information for us today. Who do you work for?
Well, traditionally, when I started off, I started working for a lot of builders, both small custom builders all the way to kind of your large production builders. But over the years, over the last 10 years, it's really kind of evolved into working with a significant amount of homeowners, as well as architects and engineers and some other design professionals in the industry, and of course subcontractors in the business, because construction industry is large. There's a lot of people that need help, and we like to give it to them.
Good. Sounds good. All right. So let's talk about some consumer issues. I know, a lot of consumers buy production homes from builders, and they go in, they like the house, they like the floor plan, they sign the contract, they move into the house, everything's great. But what happens when something goes wrong? So the drainage never works right and the builder won't fix it, or they come in and fix it and it doesn't really fix it, What kind of recourse does a homeowner have? Is there anything they can do about that?
There sure is. The issue that most homeowners have that they don't even realize is that they do have the power to go back to their builder, but they've got to do it the right way. And there are laws out there that they must comply with. Okay,
how are they going to find that information?
Well, actually, on their earnest money contract that they sign right before their signature is going to be in about 10-point large font, bolded. It says, "This contract is governed by Chapter 27 of the Property Code." Most people have no idea what that means. They're just so happy to sign the contract to get the home they want.
House.
That's right. They are thrilled to death that they got the house on the lot that they wanted, that they'll sign just about anything you put in front of them. Well, that chapter in the Texas Property Code is a homeowner's most important statutory scheme that they need to be aware of, because the builder's going to have their warranty program, and they're going to have the ability to submit probably over the internet their concerns and claims. But the real issue that you're getting at is, well, what happens when the builder gets them, doesn't acknowledge them, or just doesn't fix it right ever? Well, you as a homeowner are required by Texas state law to send a letter by certified mail describing in reasonable detail and providing any documents, photographs, engineering analysis that tells the builder what is wrong. And the reason why that's important is because until that happens, most builders really don't have any obligation to do anything. And the reason why is because they make money selling you a house. They don't make a lot of money handling warranty calls. So, and again, I see this more often in the smaller builders, the custom builders, and other areas. Your larger production builders are, to be fair, they usually handle it pretty straightforward.
Yeah, I can tell you, I have a production home, and honestly, before the 1-year warranty was up, they were calling me saying, "Do you have any issues? Your warranty's going to be ending soon. Is there anything we need to come in and fix before it ends?" So there are some great builders out there that want to make you happy, want to make sure that you're happy with their product. But then I hear horror stories from those consumers who, have some issue with the house, and the builder they may come in and address it, but they just don't get it right. And it leads to other problems down the road for the homeowner.
That's right. And really the only way to force it is to send that certified letter. That's the trigger. That is the most important feature, because then the builder's on notice that they must come out. They've got 35 days to come out and inspect it. They get an additional 15 days to issue what they call an offer of settlement. And if they don't do those things, If they fail to go forward with it at the expiration of 60 days, you as a homeowner can take action. You can take either legal action or through, depending on what your contract says, you can initiate an arbitration proceeding.
Wow, I bet most homeowners don't know that.
Most of the homeowners that come to my office have never heard that before.
So is there a statute of limitations on that?
Well, in general, there is with respect to construction, and it depends on the type of claim that you're going to have. In construction claims, you're going to generally allege that someone built this section, this roof, this whatever, negligently. That negligence cause of action is going to have a 2-year statute of limitations. So if you don't bring that claim within 2 years, you're going to have some issues. Now, of course, as well, if you're going to claim that they breached their contract by not building you the home that they agreed to build for you, that's a 4-year statute of limitations. Now, of course, there are some savings clauses. There is, if the defect is hidden, if the problem's hidden and it's latent and you can't find out about it because of concealment and other issues, that can actually open up the statute of limitations to make it go longer.
Okay.
But you just need to be diligent.
So now, there's something interesting that I don't think a lot of homeowners know. Anybody can be a builder. Is that right? Is that really true? You don't have to have any training. You don't have to pass any tests. You don't have to go to any schools. I mean, anybody can be a builder. Is that right?
That is correct. There is nothing in the state of Texas that requires a builder to be licensed or registered or anything. In fact, I know a lot of builders that just show up in their individual capacity and have a DBA, Sam's Construction, and it's just them. And most homeowners don't know, or actually most consumers don't know to do any type of diligence.
So how should a consumer check someone out? If let's say there's a small custom builder, nobody's ever heard of them, but they go and they look at a few houses they built that are really nice and they want to use them. How do they check them out? Well,
you raise a great point. I think referrals and going back to other homeowners that have purchased a home or built with them is a great place to start. I've been a member and have been affiliated with the Greater Houston Builders Association for over 10 years. They have a tremendous amount of resources. I would certainly recommend homeowners go there to take a look at, has this builder been involved with the GHBA? Are they on any of the councils? Or do they sponsor? Do they participate in events? Those are all, indicators that this is someone on the up and up. And then, unfortunately, one of the things that you may want to do is come to find someone that can go search the court records. Because what I've found is a lot of those builders, there's a lot of lawsuits against them. And if they're not paying their subcontractors, if they're having disputes with their homeowners, you'd rather know about that now.
Absolutely. Yep. So what about the developers? There are some communities that get started. The developer comes in, puts in utilities, cuts the roads, and a few houses go up. Some people buy those houses, and then next thing you know, the builder's gone under, and the pool's not being built, the clubhouse isn't being built, there are no more houses being built. What kind of recourse does a homeowner have, or do they have any? What should they do in that situation?
Unfortunately, more often than not, you're going to have very little recourse, because that developer and those builders, traditionally there's going to be an agreement between the developer and the builder that the builder is going to take down a certain amount of lots in a certain amount of time. Oftentimes that developer may have an interest in that builder, they may not. It just depends on what their relationship is. The hardest part in those situations is you almost basically don't want to be within the first 10 or 15 homes. You just don't want to be the guinea pig on that development. What you want to look for is a development that's thriving, that has a lot of construction activity, that is proceeding. Because if you come across a development that's got 100 lots and only 10 are built, that's a real good indicator that this development is struggling to get by and struggling to find people. So you kind of have to use a little bit of common sense and kind of check your gut before you go in there.
Mm-hmm. And I know there's some communities that kind of went on hold when the economy got so bad, and now the economy's coming back. The builders are getting back in there, starting up again. So I'm guessing you kind of have to be leery about that as well, because that's kind of like starting the neighborhood over again.
It really is, because most people are sold on a bill of goods from the original developer, and that's what they've come to expect. And you're right. I've actually been involved in 3 or 4 of those types of situations on communities that were 50% built. The developer goes out of business. They're obviously not paying any builders to come in and build. And then it's, okay, these are great communities for someone to pick up on the cheap. And so what you have is you have these real estate investors that come in looking for distressed properties like this to buy up at a much reduced rate. I mean, traditionally those lots in those communities will go for $25,000 to $35,000, but these real estate investors are picking it up for $10,000 or $15,000. So they oftentimes want to put in a different product as well, and they don't have the investment, and it's probably a poor word choice, but they don't have the investment in the community like the original developer did. This is truly just, how do I make the most money out of this project and get the most people in here?
And with regard to homeowners association, the developer and the builders have the biggest chunk of membership until it's completely developed. Is that right?
That is traditionally how they're worked up. They're known as the declarant in the legal documents. Is that the builder and or traditionally the developer will actually have the majority vote and majority say in a homeowners association until it reaches a certain level of being built out. Oftentimes it's 100%, sometimes it's 75%, and then the homeowners get control of it. The biggest problem I've seen in those situations is the declarant's required to fund the homeowners association, and more often than not, they just simply won't do it.
Well, the issue that I have seen is that the deed restrictions basically say that the house has to be, at least 2,000 square feet, for example. And then the developer will go in, since he has control of the HOA, and lower those standards to 1,500 so he can bring in a cheaper builder that the residents don't want in the neighborhood. And it just kind of keeps declining and declining, being able to bring in cheaper and cheaper builders. There's really nothing homeowners can do about that, right?
It's going to be very tough. One of the few things that you can do is and of course I'm the lawyer bringing this up, but one of the few things that you can do is find some legal assistance to file an injunction to prevent them from doing that. That there are rights that you have because you did buy in a community. It's usually going to be a fairly tough road because the biggest problem is that you're going to need all of your homeowners to be in it together and be one voice, and that's one of the hardest things to find. In my practice, I've only been able to successfully bring those claims for about 3 or 4 communities. There's been a bunch of others I would have loved to have helped, but there was too much division amongst the homeowners.
Right. I find that a lot of homeowners just, I know in our area, they don't want to sign anything, whether it's right, whether it's wrong. They don't want to be a part of it. They don't want to sign it. They don't want to know about it. They just don't want to get involved. So, you've got a lot of homeowners just sit on the sideline. You can't, you just don't have participation.
And the biggest problem with that is then as their home values decline, they're unable to get the benefit of the bargain. And if they do want to sell their home and get out of what they consider to be a bad area, they're going to take a massive, massive loss.
Right. We've seen that in a lot of communities since the recession. All right, we're going to be right back with more here with Ian on Houston Real Estate Radio after a word from our sponsors.